So welcome everyone to our third webinar as part of Smarter Legal Week. My name's Aaron Dunn and I'm joined by Chris Hill again. And today we're going to be focusing on the topic of SMSF Powers of Attorneys. So Chris, this is an area that you have a lot of interest and passion about. And one of the things that people will note on today's slides is we have a different logo. And one of the things that you have been developing over the last few years is the Inherit Australia business. And from today's session, you're going to provide us a bit of insight into what you've actually been developing in that space. So maybe as we kick off, just a brief intro into Inherit and what you've done in that space.
Yeah, thank you, Aaron. We developed Inherit, that is myself and my business partner, Raf Cohen, my tech partner, developed Inherit for advisors to be able to provide estate planning facilitation conversations with their clients. And we had feedback from a lot of advisors, particularly in the SMSF space, where they wanted to talk about how they could have a conversation around death benefits, benefit planning, and how that fit with the estate. And so what we did is we developed a whole new platform which allowed advisors to have conversations, connect with specialist lawyers in each state of Australia, and to drive that process forward and to make it a revenue opportunity for the advisor as being the trusted advisor through the client relationship.
Yeah, and I guess, Chris, this is the evolution and part of the evolution this week as well in terms of developing Smarter Legal Week is the fact that this document that we're going to be talking about today, a special type of enduring power of attorney, is enlivened by the Smarter SMSF deed. So things that we have continued to evolve and develop. And I guess as part of the construct of this week, and when we thought about the topics that were relevant, we were very deliberate in kicking things off with the Smarter SMSF deed and the must-haves that you should have in that. But the next couple of sessions incorporating today really will talk to some of the key features that we actually have in the deed and practically how these can be used within your SMSF client base.
Yeah, and I think this is about helping advisors identify strategies with their clients and how to, as you say, use the deed or enliven the deed to add value to your clients and to your practice. And today's topic and the case study that we're going to launch into very shortly is actually based on a real life scenario in my practice with some modification that you will see in your practices as we open up the topic.
Yeah, absolutely. So in terms of what we're going to cover today, I'll do a bit of an insight to kick things off, and then I'm going to let Chris really drive the conversation about this. As Chris just mentioned, this is taking what he is seeing each and every day and a client scenario and the peaks and troughs that I guess they go through in getting to some of the decisions that have ultimately been made. So we'll look at the issues around what happens when a member loses capacity in the fund. The topic of capacity and what is it is something that Chris, you and I talk about quite regularly and in terms of how that needs to get looked at and incorporated in the context of the deed. And then, as we said, we're going to really flesh out this topic through real case study and really highlight some of those issues that have evolved and then what steps need to happen from there. And then finally, we'll jump into how you can look to incorporate this with your clients by ordering and the fact that you can start the journey from the Smarter SMSF platform with our integration with Inherit to enable you to look at the ordering of those SMSF power of attorney documents. So Chris, I'm going to hand the car keys over to you to drive and hopefully that's all working. We can get underway.
All right. Okay, I think I need to just click on the screen. Yep. Here we go. All right, so everyone knows, or most of you would know the current trends with SMSFs. It's growing in the market. 30% of all super assets approximately, as at June last year, $878 billion is sitting in SMSF funds throughout Australia. And that's predicted to grow at about 5% per annum. Added to this is we have an aging population. 16% of the population as at 2020 is 65 or over. And this is projected to rise to about 23% by 2060. Then we have issues of elder abuse in the community. Based on the National Elder Abuse Study a few years ago, 1 in 6 Australians are experiencing elder abuse. And with an ageing population, we also have increases in dementia rates. It's projected that there'll be 6.4 million Australians who will be diagnosed with dementia in the next 40 years, which is going to cost the community significant amounts of money. And so all of this is a recipe for major significant issues that you will experience with your client base around incapacity and with this ageing population and their SMSFs.
Yeah, so Chris, one of the things that we mentioned the other day when we look at our client base is the fact that we have more diverse SMSFs than we've ever had before. And when I talk about diverse, it's not only diverse in investment strategy and the way in which SMSFs are investing, but it's diverse in terms of member demographic and profile. So statistically, we're seeing more and more younger entrants coming into the system, but many of us will now have clients in their 70s and 80s and 90s that really didn't even consider those things a decade or 2 decades ago when these funds were in their sort of infancy. So looking at and addressing these types of issues around dementia and decline are all crucial, which is why the ATO in a lot of their messaging thinks about when we're setting up funds, that funds are putting in place an exit plan at the same time. And this is, and again, I made the comment in the past couple of days about the government's really focusing on this as part of the superannuation in retirement focus more broadly, and how then the retirement income covenant might fit into the SMSF space, because of the fact that if in an SMSF someone loses capacity, there's not only membership considerations about that individual, but the trustee structure also gets impacted by that, which it doesn't occur when we think of it in APRA land.
Yeah, and we're also seeing with the 6-member funds, more family-related funds, which creates its own challenges in between the generations, between parents and children. But of course, the question here is when there is an incapacity or there is a legal disability, and the requirement, as most of our viewers would know, is for the member to step down from the office of trustee or director of the corporate trustee, and they need to be replaced by their legal personal representative, which is defined under the SIS Act as their enduring power of attorney. And in those circumstances, the assets have to be physically transferred, if there is a member trustee, to that attorney. And as we know, the failure to follow this process can render the fund losing its complying status, particularly after a period of 6 months. And of course, that then raises the question is, what is incapacity in the context of this definition of legal disability? Incapacity, what does it actually mean? The SIS Act, which is a 1993 piece of legislation, hasn't been updated around this definition. It doesn't define it in section 10. It just says legal disability. At common law, a legal disability can mean a number of things. It can mean a person who's bankrupt, mentally incompetent, unsoundness of mind. There's no clear definition in the Act. And then when you look at the states-based legislation, you know, there's no definition of legal incapacity no common definition of legal incapacity in any of the state-based acts. We're talking about the Powers of Attorney Act. And for example, in Victoria, we have the definition of lack of decision-making capacity. In New South Wales, we have this definition of incommunicate. And in South Australia, it has no definition at all. And so faced with that lack of clarity, we also have the issue of what is the level of impairment that's required for a member before they have to be removed. And remember, when we're talking about incapacity from a mental health perspective, the decline is degenerative in nature. So where do you draw the line in the sand between they do have capacity or they don't and have to be removed? And we've got the 6-month period. This is a really significant issue that hasn't been addressed in the context of all of the legislation. So what I wanted to do is sort of to try and unpack these issues and highlight the shortcomings of a standard power of attorney, and certainly a fund without a power of attorney, with a real life case study. And we've changed the names and descriptions for obvious reasons. We're talking about the Johnson family SMSF, and this client and these circumstances, I have no doubt will be in each of your client bases in one form or another. Now, this particular case had a cocktail of problems, which we'll unpack as we go through this. So the Johnson family, like a lot of families, had an SMSF, Johnson Family Super Fund. They had $4.5 million worth of assets, including a factory that Peter had transferred into the fund when he was running his engineering business. Peter is 88 and Mary is 76. And unfortunately, Peter has been diagnosed with early stage dementia, and his doctor picked this up with a mini mental state examination that he conducted, which was 18 out of 30, which is an indication of early dementia. Now, Peter, of course, like many people, like many of us, are in denial, right? We don't have any mental health problems. I'm okay. However, Peter's wife, Mary, suspects more, and she is saying, look, Peter, why don't you undergo, and this is what his doctor says, go and have a PET scan to determine whether you've got how serious this problem is. He's in denial. And added to that, Mary suspects that Peter has had a gambling problem, and because she's noticed significant monies being withdrawn from the fund. And Mary suggests, based on advice she's received, suggests to Peter that he steps down, but of course he refuses. Now, the issue then, if I can move to the next screen, is at what point should Peter be removed against his wishes? You know, and how do we achieve this? How do we physically achieve this? How do we mandate it, or how do we avoid the fund becoming non-compliant in these circumstances? And what if Peter says, I'm not going to undergo, as he said here, any further testing beyond the doctor test that has been performed? And how do we determine his level of incapacity to force him to cease office? And equally, in fairness to Peter, how do we avoid, in the case of elder abuse or risk of elder abuse, how do we avoid Peter being forced out of office? Like, maybe it's coming, but not yet. How do we know that? So this is a real issue. Now, if we expand the family circumstances a bit more, Peter has been very successful in cryptocurrency trading. Not many people that I know of have, but he was very successful. And he had, as a result, the largest account balance in the fund. Well, not necessarily as a result of that trading, but by virtue of his contributions, he had the largest account balance. And by virtue of the terms of the deed, he had control of the fund. Now, Peter, in this case, had a child from another relationship, James. And he wants James to become his attorney, you know, to take over the fund if and when he becomes incapacitated, in his point of view. But of course, well, not of course, but as happens in blended families, there's estranged or relationship, estranged or strained relationship between James and Mary, the stepmother. And Peter also expresses some concern that James has also got very much into real estate ventures, and he doesn't want James in the fund if he could avoid it, because he'll use the money and do other things if he loses capacity. Now, you know, if James is appointed as a power of attorney, in the context of a general power of attorney, he would step in when Peter does lose capacity, when he does agree, or when we can remove him, he would step into the control of the fund. He would have control based on Peter's account balance, and that could create its own problems in terms of dealing with Mary, because there is already a strained relationship, and he may make decisions that may not be in the best interests of either Mary or Peter, his father. And I think it's important to note that whatever restrictions are put into the enduring power of attorney document, and you can, and the powers of attorney documents in each state of Australia allow you to write your own powers and restrictions or limitations, evaporate or are non-binding as soon as in this case, James or the attorney, steps into the office of trustee, those powers are non-binding. It's the terms of the deed that now then operate to embolden or constrain James, if this is the case, as the attorney.
Yeah, so Chris, that's a really good point to raise at this, because quite often we might have maybe joint attorneys, and there's maybe a decision at that point in time. Do we want both individuals to come in and act as co-trustee for that member? And one person might go, well, look, it's a bit more tricky for me to do it. So maybe I'll get another part. I'll get the one of the two to come in, or one of the three to come in. It's important to understand the impact of that. So the fact that the ATO says, well, that you can do that, there's no problem with that. But the decision-making power then rests entirely with that one person in the fund, not with the three of them that has initially been granted.
Yeah, and even that, if you take it a step further, if you have the two attorneys as the replacement trustee, what happens if they are in conflict in relation to their father's power? Do they have to act unanimously, or is it joint and several? How do we deal with that issue, which is a real live issue if the attorneys can't agree, right? Put aside the other member, in this case, Mary.
Yeah. And I know one of the things that we've spoken about a lot, and we had the initial conversation on Monday with the deed, is that it is an ordinary by majority decision-making process that things naturally occur within the fund. But over time, maybe there needs to be some sort of shift in how decision-making then occurs within the fund. So does a situation like incapacity move from what is a simple majority at more than 50% to have to become either a higher benchmark, maybe it's 75, or does it then have to become unanimous within the fund? So again, these are all crucial decisions that need to occur from a deed point of view, that tie back into the conversation we're having here.
Yeah, and especially, and it becomes more acute where you've got more than one attorney seeking to hold the office of trustee.
Yep.
Right? So if we take this a next step further, Peter reluctantly agrees to have this PET scan, right? Mary's been on his back. During the process, he's injected with a dye and he passes away. He has a stroke. And as the surviving member, Mary now receives a death benefit income stream from Peter's reversionary pension. So what does Mary do? Knowing nothing about cryptocurrency or SMSFs investments generally, she engages a financial advisor, and that's probably one of our viewers to this session today, to assist her in managing the fund's investments. And she relies on his expertise, and she develops this relationship of trust with the advisor, as you would expect. Mary also has a daughter from another relationship called Jane, who is a notorious spendthrift. And Henry talks to Mary about, well, you know, you've had the same problems with Peter before he died. You need to have an attorney appointed for your fund. But of course, she's in a dilemma. She doesn't have anybody. She's got one daughter who would be notoriously the worst person to put into the fund as an EPOA. She would just run amok. And of course, what does she do, like people do? She asks Henry if he can be her attorney. But of course, as we know, Henry can't act as attorney for a number of good reasons. He would have a conflict of interest if he was a financial advisor. His dealer group would prevent that. He wouldn't be covered for PI insurance in respect of his functions as a trustee. And of course, he can't even charge for his services. And why would he want to take on the liability as a fiduciary office holder of a fund of which he has no financial interest? This is compounded by the fact that there's also more estrangement between Peter's son James and Mary because of the death of the father. You know, in this case, she blames Mary for forcing his father to go and undergo this PET scan, which led to his demise. So, you know, so appointing Jane, if she was able to or wanted to, could create a significant change in the whole dynamics of the fund and of course, the risk of some form of financial abuse. Now, what's also happened here, which is added to Mary's woes, is that Peter's binding death benefit nomination lapsed upon his death. For those of you who attended our session the other day, it was one of those Regulation 6.17A nominations that did not follow the benefit or the opportunity from Hill and Zuda. It just reverted back. And of course, the nomination had lapsed, which, as we know, is now a discretionary nomination. Now, of course, when Peter did his will many years ago, he appointed Mary as his executor. And unbeknown to, well, subsequently known before Peter's death, Peter had appointed James. Knowing that it was against Mary's wishes and knowing the conflict, he decided to appoint James as his attorney. And what that meant was that James eventually became the trustee of the fund, or assumed the role of director of the corporate trustee, despite Mary's dismay. And of course, when Peter passed, James assumed the office of power of attorney. He got the advice from a lawyer, and I think this is very sage advice, that based on the recent case of Dawson, he could remain in office as a trustee of the fund, even though the power of attorney ceased, which is what Dawson and Dawson held. And what did he do? He took the view that because his stepmother got most of the estate, in fact, all of the estate, and believed that he wasn't going to get paid anything when she died, he paid himself 60% of the death benefits. Probably read Marcella's case and thought, well, if I give it all to myself, it would be an invalid exercise. So he gave himself 60% of the death benefits. When Mary thought, and there was a significant death benefit because she had a reversionary pension, but of course there was an excess transfer balance here, she was expecting the balance of the super to be cashed out to her as a death benefit, which was what Peter had provided in his nomination. But of course, we now know it's non-binding, and we have James in control of the fund making this decision. And so this underlies the importance of doing something different to address all of these issues. And what I want to unpack in the time available is the value of having a special purpose SMSF that can only be provided at the moment in Australia with the Smarter SMSF deed. And it solves all of the issues, and I'll unpack how we solve these sort of issues with this particular case study and other scenarios. And what it's designed to do is give greater protection from elder abuse or mismanagement and families in conflict. And it's designed to allow you, as the trusted advisor, to be the fund guardian. And we'll unpack that a bit more in a moment. And we'll certainly talk a bit more about fund guardians tomorrow. But the idea is that clients who have relationships with you want you involved in the management of their affairs. You've helped them develop their wealth. And it's only natural they want you to be part of the management of that wealth, particularly in an SMSF context, during a period of incapacity and probably on death as well. And of course, the dilemma, as we saw earlier, is that advisors can't become a trustee, and they don't want to won't have any ability to have a role or function unless the attorney engages them, and that may not be the case. So what we've done with the guardian is to remove any fiduciary obligations of trustee, but to give you a power of supervision and a power of veto. And as such, you can charge for your services as your client would expect, and we can provide a drop-down list of selected restrictions which can be imposed on the trustee. And we do that through creating 3 types of powers in the power of attorney document, and by making the power of attorney document a special rule of the fund and a paramount document. So effectively what we do is we create a document that is hardwired into the fund through the special rule features of the Smarter SMSF deed. These 3 powers, the express powers, are those powers or functions that the client says, look, I will allow my attorney to make those decisions. So if we were talking about Jane here being nominated as the only sort of child or surviving child of the family, for Mary's daughter. She would maybe have an express power to, instruct the fund's accountant to prepare the returns. We can carve out specific powers when creating the power of attorney that she can have without any restriction. Then there's, on the other end of the spectrum here on the screen, the prohibited powers. So we might say, I don't want Jane to be able to commute my income stream, to cash out, to roll over, to augment it, to add members, or to change the investment strategy of the fund. We can create that as a prohibited power. Or we may select powers that we might say, yes, you can exercise, but you've got to get permission from my fund guardian. You've got to get permission from Henry, my financial advisor, who's going to be my fund guardian. So that may be changing the advisors of the fund, right? Maybe Mary just wants Henry to be involved. She doesn't want Jane to throw Henry out of the office of advisor to the fund. So that may be one consent power. It may be things like commuting pensions or changing investments.
Yeah, so Chris, I was just going to say there, so the commutation of the pension here under that consent power might be that we have the member going into aged care, and then there's a RAD that needs to be paid for or something to that extent. So therefore, the guardian that's helping to oversee that knows the situation and in essence forms maybe part of the advice that they've been working with the client with anyway, and therefore that decision that is to occur, the guardian sees that as a prudent decision that is being made by the trustee.
And what Mary might do is say to you, look, Henry, as the advisor, look, I want to go to this facility and the RAD's going to be $1 million. I've got $4.5 million. Peter left me $4.5 million. I want to go into this facility. It's got chandeliers. I can get Foxtel, and this is where I want to go. But I don't trust Jane will send me there. She's thinking about her own interest. She may send me somewhere else where it's no carpet on the floor and the RAD is $400,000. I want to go to this facility, and I want you to, consent to commuting my pension, but only to go to fund this particular RAD. So that's a scenario where you can play a very major and important function in meeting Mary's wishes, but looking after her best interests.
Yep. And there was a question just said, Deb's asked, would this not be an SMSF audit nightmare? The reality is the auditor, from a compliance perspective, all they need to look at is the fund meeting the definition of an SMSF? That's all that needs to happen around 17A. So what we're looking at is we'd be looking at any EPOAs that have been appointed, and then the role of the guardian falls outside of that definition. So the prescriptive nature of what we're talking about here with these different powers and what's contained within the document has no relevance or bearing to the context of what an auditor would need to look at each and every year.
Yeah, we're not changing the players in the whole scheme here. We're just controlling the powers or the functions of the replacement attorney, the new trustee, replacement trustee in the context of a decision.
And remember, it goes back to the same concepts that we've spoken about in trust law for long periods of time with a family trust or a unit trust or something. These sort of powers are built into the deed ordinarily. It's just the fact, and I go back to my comment that I made earlier, we now have far more diverse client portfolios of SMSF clients. So now these things are now coming to the fore a lot more, but we need to ensure that we are ticking those compliance boxes, but then constructing the deed and those documents that we see as being intrinsically linked to them to become special rules of the fund and paramount documents, again, as we spoke to about on Monday. And now we're starting to enliven this by today's session to show you how and why we've actually built these into the Smarter SMSF deed.
And I think what we're trying to do is bring the deed that has got all of these features into the 21st century, into the modern family, recognising that we have diverse families, as you've mentioned, but we also have different expectations between Generation Z and the baby boomers. One accumulates and the other one wants to spend, and there's this tension that exists. That's why we have this high incidence and growing incidence of elder abuse. So this allows you to play a very important role to protect your client's wealth and to do the right thing by your client. And I'm sure if you explain this to your clients, they would want you involved. So what we do with this SMSF power of attorney, we address a number of these issues that we've seen in this case study. So we create a process for determining, it's a 4-step process for determining what is incapacity. And essentially, just briefly, under the terms of the power of attorney document, the replacement trustee can say, I think in this case, Peter, you've lost your marbles, or I think you should step down. If Peter disagrees, then it goes to the fund guardian. If the fund guardian says, look, I think I agree with James, you know, Peter, you should step down. And in fairness to Peter, he says, no, I think you're both wrong. Then Peter has to undergo a cognitive assessment. And there's a requirement for him to step down until that assessment is performed. And then that assessment will determine once and for all that whether he has capacity or not. And that will be performed by a geriatrician or a neuropsychologist, noting that most general practitioners now don't want to make or reluctant to make capacity assessments, particularly if there's some sort of conflict sitting behind it. So we built that into the process of the EPOA, hardwired into the deed, that allows the definition of capacity, because we do have it varying in each state. We do not have consistency. And so we need to be mindful of what standard are we going to apply? And in fairness to Peter, avoid a situation of abuse. I have seen cases where kids want to throw dad out of the fund way earlier than dad should do, because they just, that for their own self-interest, they think he's lost capacity. And given our comments earlier about where capacity, what level of incapacity should trigger that change is very subjective.
Absolutely.
We also deal with the issue of what should happen when the attorney, referring to Dawson's case, whether the attorney should step out or stay in. And this really involves a conversation between your clients about their estate planning. Are the attorneys going to be the LPR? Are they different? And should they step out? And is there going to be a conflict? And that's why the Inherit platform allows you to take the conversation further into an estate planning conversation.
Yep. So Chris, there's another question here. So in the instance of, and I might just go back here, in the instance if Jane took money out or made investments not allowed without reference to the guardian, that would normally be allowed for under an EPA, would that not cause an issue if the guardian is outside of the fund? So, well, ultimately that's the entire purpose of the guardian, that there would need to be, in terms of the powers that the guardian have, and that is stipulated obviously in that fund guardian document, there is a mandated obligation of the trustee that holds the EPA to seek the consent. So I guess taking that question a step further is well, what happens if the EPA tried to do something where that wasn't something that the guardian would have otherwise approved?
Well, yeah, and according to the provisions of the SMSF power of attorney, that exercise of a power would be invalid as far as the attorney is concerned. And it would be essentially a breach of trust, because it's a breach of the terms of the deed.
Yep.
Right. So, and so this means, obviously, from an advisor's perspective, jumping into the saddle of fund guardian, you need to have access to the bank accounts and have some sort of supervisory monitoring of that. As part of your retainer and part of your services and fees that are charged. But I think that's what a client would want of you if there is concerns about the capacity of the attorney to hold the fiduciary office of trustee, right? Whether it's through possible deceit or ineptitude, either way, clients usually want their advisors involved somewhere in the process. And this is a way where you can be involved and have some sort of authority without having liability or responsibility.
Absolutely.
So I think moving now, we just want to show you how this all works with the Inherit platform. How do you do this, right? And we want to allow some time for discussion. We've got a bit of time available, but we just want to show you how you connect with the Inherit platform. So, so you would go into, this is your new platform, right, Aaron?
Yes, it is. Yep. So that's the I guess the documents list page. So one of the things that you can see, and I'll jump live, and I know we've got some screenshots in here, but I might just quickly show people the navigation. If I can find the
while you're doing that, it'll say Victoria SMSF Power of Attorney, but we've actually now got SMSF Powers of Attorney for Victoria, Queensland, South Australia, and by the end of the day, New South Wales.
Yes.
Even though it's not listed on this site here.
So I'm going to.
And more states will be added as the take up occurs.
Yeah. So what we've done on our new platform now is where we have an image, so a logo that sits on the right hand side here. This is where we have some form of integration or connection, in essence, to the relevant provider. So we spoke yesterday about the Smarter Legal Review Service. So the deed of rectification there is done through Chris's legal practice at Hill Legal. But equally here, as Chris was highlighting, we have the ability to produce that enduring power of attorney, or in this instance, the SMSF Power of Attorney. And what that will do is that will then bring you across to the Inherit site. And then you can see it then starts to ask you some particular questions about that registration process. So I'm not going to sort of jump into that too far, because we'll sort of take you through some of those slides. But that is where you can start the journey. So you can literally start the journey from the SMSF, Smarter SMSF platform, connect for that first time. So in essence, it will require you to sign up, and then you'll be able to get underway. And I'll come back and sort of show you that live environment in a little bit more detail shortly. But Chris, let's jump back to the slides and go through that next stage.
Yeah, and so once you register, it's a once only registration. And once you get into the environment, you can generate the SMSF Power of Attorney for those 4 states. Or if you want to start an estate planning conversation with your clients, and certainly come back to us if you do want to do that, we'll show you what that process looks like. So what you do is, you can see there, you log in, you fill in your details, your name and business details. And going to the next screen.
Oops, sorry.
Okay. There you go. So this is a picture. This is a representation of the dashboard that you get there, right? So you then click on Start Power of Attorney. I don't know if I've still got control. There we go.
Yep.
And then you just select the state, right? And whether you want a normal power of attorney, which you can order, or a SMSF power of attorney, a special purpose one, which has all the features that we've been talking about today, you then start walking through the process. You put the name of the fund, it's select the members, and then you get to this section where you can select the permitted powers, or what we call consent powers, prohibited powers, and the express powers. And this gives you a drop-down box of all the different powers and functions that your client may want to say, yes, that's okay. No, I want you to have I want that to be a consent power. I want you to be able to say yes or no, or veto it. And then there will be some of those powers to, no way, I don't want anyone to roll over or commute or cash in. That's a prohibited power, right? So, so the client, this allows you to have a deep, bespoke conversation with your clients about this document. It's not just a template, it's a live document like the SMSF deed. It becomes a live document that's tailored to their individual circumstances. And then, of course, what happens is you can, in Victoria, we've got the facility for digital witnessing. We don't yet in each of the other states, based on the Powers of Attorney Act. We think that will eventually follow, but in Victoria, for advisors wanting to use this facility, there's the ability to electronically have this signed with, in this case, possibly a lawyer involved, and that could be either someone in my team on the legal review panel or on the legal panel. We've got 12 lawyers from different states of Australia, depending on where you're at. If you want or you can get a local lawyer or somebody else to witness this. But for electronic signing, obviously, this is only going to be available for those advisors in Victoria. So next screen, Aaron. Yep. There we go. So just what does it kind of cost and what's included? It's $200. There's a lot of value in these documents. There's a whole bunch of them. There's the special purpose EPOA, signing instructions, member requests. As Aaron touched on earlier, the ability, we've got minutes of meeting to make this a special rule of the fund and a paramount document. That's not available in any other deed in Australia. So this is only available to this Smarter SMSF deed. There's no other deed that will allow you this level of flexibility. And then we've got the deed of appointment of fund guardian and a very detailed explanatory guide that you can give to your client about the whole process and how the document could be used, and some FAQ questions, that can be of some relevance. So there's a lot of value.
Yeah, so I was just going to say here, so just for everyone's benefit, so there is the ability via Inherit to be able to produce enduring powers of attorney ordinarily. So to be able to satisfy the definition within 17A3, and the fact that that EPA can be prepared and you can do that ordinarily, don't need to be linked to the Smarter SMSF deed. Yes, you can connect via the Smarter SMSF platform to do that. But if you then want to drill down and look at these different aspects in respect to what we refer to as an SMSF power of attorney, if you produce that document, you must have the Smarter SMSF deed for that to actually apply, because of the functions that we've spoken about, not only today, but in the past couple of days, insofar that that document then gets annexed to the fund by virtue of it becoming a special rule, and ensures that it is as high of a document in terms of its priority as to anything else, and then in the event of conflict, that it is referred to as a paramount document. So that is the document that the trustees must refer to in respect to the decisions that will apply around what is contained within that SMSF power of attorney as well.
Yeah, so I think that's a good point. There'll be some of your clients, and perhaps many of your clients, who probably don't need a special purpose SMSF power of attorney, but we would advocate that every fund should have an enduring power of attorney to avoid breaching that complying status. So you could use a generic power of attorney, which is on the platform here, on the Inherit platform, that you can use with any fund, as Aaron's mentioned. We're focusing today on some of those difficult scenarios, or just scenarios where a client may not have all the complexity or issues, but may want you involved, just as an advisor.
Yep. So yeah, so just wanted to sort of do that distinction, so you can then see there the ability to create the different type of power. If I just choose Victoria here, and then you've got the choice of a standard enduring power of attorney, medical, a combination, or the SMSF power of attorney there. So you do have that flexibility, but noting again, because we do want to make it very clear, like we do with a range of other specialist documents we have on the platform, some of the work that we've done in respect to this, our lost pension deeds and the like, are all specifically linked to the fact that it is the deed of Smarter SMSF that you need to go to. So if you want to produce it, that's great, but you should also ensure that you may need to do an upgrade to the Smarter SMSF deed in that first instance.
Yeah, and we've already seen in today's, I think, SMSF magazine, reference to the importance of estate planning, being part of dealing with death benefit planning. And with the rise of the account balances and the amount of funds that are going to be in excess, the question clients are going to be asking is, well, what's going to happen with the excess? Is that going to go to a beneficiary, or is it going to go to my estate? And this is really going to drive you into a conversation about the client's estate planning. And for advisors who are, very much focused on the value end of the process and trying to protect their business with connecting to the next generation, the Inherit platform gives you that opportunity if you want to take that further. We've got other tools such as the Life Vault, the estate planning health check, which you could use as another service as well.
Yeah, so Chris, the other thing, and I might just go back to the platform as well, because it is probably the elephant in the room, and it is in a lot of instances as people look to prepare certain documents, and it's why we introduced the Smarter Legal Review in earlier this year as well, is the provision of the advisor, the trusted advisor, doing this work, or the collection of this work, and then the production of that particular document. So does it overstep, the mark in terms of what they can or can't do ultimately? So does this become legal work, and therefore is there concerns with them trying to undertake this?
Yeah, look, that's a good question, and I think we should unpack that. We've got 10 or 15 minutes before we jump onto some questions. We see an SMSF enduring power of attorney no different to any other online document that you can order or provide, any other online legal document, if I put it that way, whether it's from Smarter SMSF or elsewhere. Looking at the case authorities, and I know Aaron and you and I have discussed this earlier, the case authorities make a distinguishing line between being in the business of providing legal advice and providing doing clerical work of a clerical nature, not providing legal advice as part of the provision of a document. So I think for advisors who don't go out and start marketing this document as their own, that could constitute legal advice. Certainly we saw that in the Quell Wills case, the 1990 case, where an organisation was promoting wills and they were held to be providing legal advice. Engaging in legal practice, which is what constitutes part of the definition of legal advice, is work that's done exclusively by a lawyer. And of course, lawyers prepare documents, but they also give advice. So the advice part of this is something that, providing you don't stray into, you should be okay. Now, we've provided you with, through Smarter SMSF, two ways of protecting you in that area. One is if you want to get sign off through the legal review service, or alternatively, you can move the clients through to a panel lawyer on the inherit panel, who will obviously, in many cases, powers of attorney have to be signed by an authorised witness, which is usually a legal practitioner, who can give that advice or address any questions of a legal nature. So that's a margin of protection to advisors. We also state in the explanatory guide that if the client, which is written for the clients, if you have any questions about the nature, the functions, the powers, or your obligations, we would encourage you to get legal advice through an inherit panel lawyer, if that's required, or externally. And some advisors are saying, well, look, if I really want to mitigate risk, I will invoice the client separately for this cost and add my time, as a margin, because I'm obviously preparing a service, so it's separate. But we've addressed it in that way. And I think if on the front of the document, it's a white label document, it's not going to have the advisor's details on it. It says very clearly, this document has been prepared by Hill Legal under license for Inherit. So it's very clear that this is a legal document that is provided by a lawyer. And providing you don't hold yourself out as being the lawyer or give legal advice, I think you're perfectly fine.
Yeah, absolutely. And the other question, I think it's sort of come in a couple of times here as well, is the fact that this is designed for the advisor and the practices, I guess, rather than individual trustees or individuals themselves. And maybe as an extension of that particular question is, well, how does the advisor really go about working through this with the client to answer some of those questions that may be within that SMSF power of attorney, so the data collection process. So, the decisions that we were talking about before in respect to, the consent powers that may or may not be granted.
Yeah, well, we've tried to sort of streamline this process and make it as simple as possible, but, focusing on the fact that there are different powers or functions, we look at it that way, that either the client might be happy for their attorney to perform without any restriction. There may be powers or functions that they don't want them to perform. And there may be powers or functions that they're happy for them to perform, but they want the advisor to say yes or no, to veto that decision. And it's really quite clear, and we step down a drop-down list that's very succinct. Now, for some clients who may want a more bespoke document, this can be part of a more scoped out process, but we've developed the powers, a list of powers, and in fact, we've selected a drop-down list of standard powers, which you can use, which probably state much of the obvious for many clients. You know, like, for example, a client may not want the attorney or the trust as replacement trustee to change the advisors of the fund, right? They may think that their attorney may go and find another financial advisor who doesn't have the same values or familiarity with you as the client. They may want that advisor to have the say in whether to do that. There's the ability in the deed to have a firm as a fund guardian rather than as an individual, taking into account that fund guardians, individuals may leave a firm or move somewhere else. So the ability to have a corporate fund guardian is built into the provisions of the deed. So it's very straightforward, as much as it might sound like there's a lot of angles to this. It's really straightforward in the process. It's stepped through and it's very clear. And I guess the best thing to do for advisors is to try it, you know, try it. If you've got a client like Mary and Peter, or have elements of their affairs that are existing with you and your client base, whether it's conflict between children or can't find an attorney or you know, those sort of issues, then try one of these documents. Again, there's the support available to modify it, to give you advice, to give your clients advice, to ensure and to make sure it's signed off properly as well.
All right. Well, Chris, that kind of takes us to the end, but we've got a couple of questions here that I think are worth us spending some time on. And for those that have asked them or want to listen to them, I think we'll take the opportunity to go through now. So the first one here, I met with a new client yesterday at an aged care facility. I've asked that he obtain a certificate of testamentary capacity from his GP. I'm satisfied that the GP will conclude that he's mentally incapable, but the issue is that due to a stroke, he is now physically incapable of signing an EPOA or will. So how can we address this in a manner that will result in a legally binding EPOA and will?
That's a really good question from anonymous attendee.
Yeah.
And look, the simple answer is that you've got to have this, what we call in Victoria, decision-making capacity, or in other states, legal capacity to sign a power of attorney. Right? You can't sign a power of attorney. And of course, this highlights the importance of getting it done, because once they lose capacity, you then have to go off to VCAT or NCAT in New South Wales or any other tribunal to get appointed as an administrator. And that comes with all the attendant costs and restrictions and of course, bureaucratic overlay. So unfortunately, if, as is indicated here, he is physically incapable of signing a will, you're sort of stuck. You've got to go off to the relevant tribunal to get an administration order, someone appointed as administration order. And that would, of course, meet the requirements of Section 17A. But it's a very cumbersome and potentially costly process, which is why we're advocating that at the very least, everybody should have either a basic power of attorney or an SMSF power of attorney for the reasons we've discussed.
Yeah, absolutely. So another one here, Joanne's asked, if you own property in other states, but you reside in, say, Victoria, do you need the power of attorney signed for that particular estate, or is the power of attorney signed for Victoria that would be okay to cover all the assets that you own?
Look, that's a really good question. In Victoria, certainly, and I think in most of the states, they recognise powers of attorney made in another jurisdiction. In fact, under the powers of attorney, it says that if there's a power of attorney made in the Commonwealth of Australia, that is recognised. And I believe there are reciprocal provisions in each of the other states. I think the safe answer would be, before you go down that path, check with us, because remember, each state has completely different, some similarity, but a lot of different provisions around powers of attorney, different processes, different forms, different definitions, different requirements. Certainly in Victoria, if you've got a client with assets in Victoria and Queensland, a Victorian power, but a New South Wales or Queensland power of attorney would be recognised.
Yeah, absolutely. They're still coming. So the document state for registering with Inherit, does this refer to the state that the SMSF is in, or the state where the deed, etc., were prepared?
All right.
And therefore executed, I would presume.
So remember, or not, I'll put it this way, the powers of attorney is made based, because this is state-based legislation, this is the dilemma for us, We have state-based legislation dealing with enduring powers of attorney, and we've got Commonwealth jurisdiction dealing with SMSFs. To the extent that the SMSF imports the notion that an enduring power of attorney can be the replacement trustee to meet the requirements of 17A, that power of attorney must conform with the rules of that state. So you will find that whilst the machinery provisions and the fund guardian deed it has all the features we've discussed, the form of the nomination, the attorney, broadly speaking, will conform with Victoria if it's a Victorian power of attorney, or New South Wales or South Australia or Queensland. So
which is why, Chris, we've got standard EPOAs that will be set up for the various states. Correct. And why the SMSF power of attorney is also, in essence, being created that way. So there isn't going to be a generic SMSF power of attorney that applies at a Commonwealth level, Australia-wide. There is going to be relevant states that are added because of that exact same reason you just outlined.
Yeah, I wish it were. It would have saved a lot.
It would be much easier to get some uniformity in that.
And it's interesting, as I've been reading all the different states, they all want to have their own power. They all want to have their own carve out, and they want it to be different, very different in some cases. Which is, one day we will hopefully have a uniform state and succession law, but all the states are going to have to agree to that.
Yeah, absolutely. So Malcolm asked, does the use of inherit where one has a previously established SMSF deed, does the deed now need to be varied? So I guess there's two parts of that, I would say, Chris. So one is, if you're wanting to use a SMSF power of attorney via inherit, you would need to make sure that you have the Smarter SMSF deed. It doesn't need to be the most current deed to do that, because those concepts have been in the Smarter SMSF deed for some time. I'd say if it predates 2017, you'd want to have a look at it. Yeah. But certainly from that point in time, I think you'd be okay in that regard. However, we do keep making some adjustments along the way, so it would be just worth contemplating that. But if you're doing a standard enduring power of attorney and you have an established deed, again, just look at the deed to ensure that the powers for a legal representative to step into the shoes allows for that sort of thing to occur. And equally in the Constitution, making sure that it's a special purpose trustee company, not potentially a trading entity in that instance.
And just a quick note on that is that with the standard, let's call standard enduring power of attorney, there is the ability to create a whole list of powers for the attorney. It's very much a bespoke document. It's not just an off-the-shelf power of attorney or template that you can get anywhere. Those powers will not apply in a standard power of attorney in the event of incapacity, as I've mentioned earlier, for the SMSF, unless it's a SMSF special purpose power of attorney. So just bear that in mind.
Yep, absolutely. And then another one from Deb here. Fund advisor firm or individual changes, or the client goes away to a new advisor and does not want the responsibility. Is there a way to be able to remove, or in essence resign from, that role of fund guardian?
Yes. So we've built that into the fund guardian deed. It accompanies the suite of documents, and recognising that a client will have a relationship with an individual who may want to cease that role and pass it back to the corporate entity, or they may cease employment and the corporate entity may want to retain that client. So we've tried to recognise that demarcation where clients become clients of a firm rather than a client of an individual.
Yeah, absolutely. And this is probably a good way. This is more a comment at the end that Deb's said, but I think it probably sums it up quite well. How easy would it be to simply have a federal level of legislation for POAs, or indeed all estate matters? Do we not live in one country? I think COVID showed very clearly that we don't live in one country, because there were very different rules around how isolation worked, and being in Victoria, we are still the world record holders. So,
yeah, and look, this is part of the dilemma that faces us and obviously our advisors. We've got clients in different states, different in the area of succession, testamentary or powers of attorney. Different rules apply, and of course we've got different family dynamics with assets across people, individuals. So we've done a lot of work in terms of building this SMSF power of attorney, but It's a monumental exercise, but it's about making sure that your clients' affairs are properly managed and you are in front of them at the time that they lose capacity or when they die.
Yeah, absolutely. Well, Chris, thank you again today. That was a fantastic session just to highlight not only the great work you've done with Inherit and the integration that we've been able to put together with that, but just to share some of those challenges that we have within our client base, and the fact that, you know, one of the things that you and I really enjoy working together with is how we actually create solutions around this. And hopefully again today, as part of Smarter Legal Week, we've been able to articulate that for you. And if you do have any other questions, you've got the contact details there for Chris and Raf and the team there at Inherit Australia. We do have one more session tomorrow that wraps up our Smarter Legal Week. It is to drill down into the concept of the fund guardian. So we look forward to you joining us for that upcoming session. Later in the month, Tim and I will be looking at the topic of pensions with our upcoming SMSF masterclass as well. So thank you everyone for being a part of today's session. Have a great rest of the day, and we look forward to seeing you again tomorrow. Take care and bye for now.
Thank you, everyone.